Good afternoon, everyone. This is Tony, the Geeky Agent from Remax, from here in Hamilton, Ontario, Canada, specifically in the subdivision of Binbrook. We are actually the village of Binbrook in the township of Glenbrook in the city of Hamilton. So we are the farthest southeast corner of the city of Hamilton, and we love it here. It's a great little spot. We got some brand new schools and all new developments and all that sort of stuff. It is a beautiful day outside. It's been swelteringly hot for the last week or so, and it's actually kind of cooled off just a little bit. We're about in the mid-20s degrees Celsius here with very little humidity, nice and sunny and breezy, and just a perfect little day here in the village of Binbrook. So what we are going to do today is just take a quick chat and talk about backing out of a real estate deal. There was a recent court, actually there's been a few recent court cases, but one in particular that was mentioned in my local newspaper, in the Hamilton Spectator, yesterday. So we're going to be bringing that up to see what happens exactly when a buyer backs out of a real estate deal. There are a lot of consequences involved. Like, most buyers don't really know. So, I mean, what happens usually with the real estate transaction is you have a real estate agent for the buyer and one for the seller, and you put in an offer for the property at a certain price with a bunch of different conditions. And then once you all agree to a price and conditions, you have an accepted offer, the buyer usually submits a deposit. That deposit is usually dependent upon how expensive is the house. If the house is relatively affordable in the $100,000 to $200,000 range or something like that, the deposit might be relatively small, like $2,000, $3,000, $5,000, something along those lines. And if the deal falls apart, if the conditions aren't met, like home inspection and all this other kind of stuff, usually the deposit is given back to the buyer without any deductions or anything like that, and everybody goes their separate ways. The seller continues to try to sell their house to somebody else. Now, if the house is more expensive, usually the deposit can be much more significant. It could be $20,000, $50,000, $80,000. And I've had clients put in deposits anywhere upwards of that $20,000 to $50,000 range. Again, depending upon how expensive the property is. It is a good faith gesture. People usually think of it that way. There's a lot of legal things that go around the deposits, and if it's required, if it's not required, and all that kind of stuff. We're not really going to get into that, but we are just be aware that that's usually the procedure. The buyer submits a deposit. That deposit sits there, and then that deposit goes towards the price that was agreed to for the house. So if it was a $100,000 house and there's a $5,000 deposit, there's $95,000 owing on closing date that the buyer has to supply, and that's usually supplied by the bank or lender that's giving the buyer a mortgage for the property. And then the seller gets their money and they go on their merry way to purchase their own home somewhere else, or whatever the case might be. Now, usually where that deposit comes into play more often in a negative way is if the buyer goes through the whole procedure, does their home inspection and all that sort of stuff, or put in a firm offer, which is the case in the story in the Spectator, and then at the last minute decides not to close the deal for whatever reason. Now they are in breach of contract, and generally speaking, the seller will keep that deposit initially to tide them over for whatever expenses they might have, while they determine what sort of damages might be involved. And damages can encompass a lot of things. So we're going to get into it. We'll discuss it a little bit more. But basically, here is I'll put up the headline here in a second from the article that we're talking about, so that we're all on the same page. But this just happened. The ruling came down from the Ontario Superior Court just last week. It was in the Spectator yesterday, but this is not the first of its kind. I did have a video about this on my YouTube channel about 11 months ago called Buyer Beware. And if you have a look on the videos on my YouTube channel, you'll be able to go and have a look at that. But I'm going to bring it up right here for you so you can have a look and see. So what we have happening here is as follows. And technology is always great when it works, and it sucks when it doesn't. So here we go. So the article is titled "A Deal is a Deal." This is from the Hamilton Spectator, as I mentioned, which is one of the oldest continuously running newspapers in all of Canada, actually. Here is my YouTube channel, and there is the video that I did last year called Buyer Beware on this exact same topic. So you can go back and have a look at that, but I'm going to cover the same stuff now just because it's relevant. And here is the article from the Hamilton Spectator, the online version, called "A Deal is a Deal, the Judge Rules." Court cases in Hamilton and Burlington show backing out of house deals can have costly consequences. We've discussed this previously, and here are the facts of this specific case that they talk about in the Hamilton Spectator. So on April 10th of 2017, which was last year, a home was listed on Upper Paradise Road, or near Upper Paradise Road here in Hamilton, which is not too far from where I am, for $469,900. The very next day, which was a very busy market back in April here in Hamilton, a couple from Brampton came in and, with the use of their real estate agent, entered into a binding agreement for $565,000. This agreement had no conditions attached to it. So no home inspection, no financing, no sale of buyer property. So they had a property to sell, but they did not include a condition in the offer that was contingent upon them selling their property before they would purchase this one. So they basically made what we refer to normally casually as a cash offer for $565,000. So just almost $100,000 more than the asking price, which was not uncommon in Hamilton at the time. The property was probably listed a little bit on the low side to attract attention and to try to attract some competition. The buyers jumped in the very next day, seeing the opportunity, and I'm not sure if there was a competition or not, or what the situation was for that particular offer, but they made a significant offer in cash with a fairly short closing date of July 14th, 2017. And basically from there, they had a firm deal. And at that point, it was just up to the buyers to make sure they fulfilled their obligations and obtained a mortgage or whatever they had to do so they could pay the rest of the balance on closing. Unfortunately, what happened was that the buyers were unable to sell their own home. So the buyers had a home in Brampton, which they were not able to sell by the closing date. And as a result, they failed to purchase the property on Upper Paradise, or just off of Upper Paradise. They could not complete that purchase. At that point, they are in breach of contract. So the sellers, like I said, most likely kept their deposit that was submitted, but also went to court. So now in the middle of July, the contract was breached. The sellers decide to go to court and seek a declaration of breach of contract, as we suggested, which would require the buyers to pay damages that result from the broken deal. Now, damages is a pretty broad term and includes a lot of different things. So if you're not able to sell your house for the same price that the buyers agreed to, that difference in price is considered damages. If you had to put you're getting close to the closing date, you've probably purchased another home yourself. You might be in the middle of a divorce, so you and your ex-spouse or partner may have both bought two different houses and have deposits placed on both of those. You may have furniture in storage. Now you're going to court, so you have additional legal costs. All of these things are considered damages. Now, you have to be able to calculate those damages. So what you have to do as a seller is put your house back on the market to see what you can sell it for. Because if you can actually sell it for the same amount of money or sell it for more money, that actually reduces the amount of damages that you're able to claim. So what happened in this particular case, we'll have a quick look. The sellers relisted the house for sale. The market had softened. Here in Hamilton, Burlington, the peak of the market is usually that April, May, June period where the sellers had their house listed. Once July comes around, when the house is supposed to close, people are on summer vacation, the market gets quieter, and especially last year, after the really record-breaking spring market we had, the summer market actually cooled down quite a bit. So they're trying to sell their house now in the middle of July, beginning of August, and as a result, the best offer that they could get was actually $435,000. So they relisted the house at the same price that they had originally listed at $469,900. Over some time had passed, they tried to market the property. They do have to prove to the judge that they did, worked in good faith, and they tried to market the property in the similar way that they did previously. But after all is said and done, the best that they could do was get an offer for $435,000, which was $34,000 less than what they were asking and $130,000 less than what the original buyers had agreed to. So there's significant damages available here. So when they're at court, the buyers actually tried to mount a defense. They tried to say, you know what, Your Honor, it really wasn't our fault. What the softening of the real estate market, in their opinion, or at least in their defense lawyer's opinion, represented what are called unforeseeable circumstances. In legal terms, that translates to the doctrine of frustration, impossibility, and force majeure. So that's how it's written there. Force majeure is, generally speaking, interpreted as an act of God, something that's beyond your control. So they're trying to argue that the fact that the real estate market slowed down and they couldn't sell their house for the price that they wanted was in a way an act of God, something that was beyond their control, something they couldn't predict, which is reasonable in a way, but I mean, the real estate market is unpredictable. You don't know from day to day what necessarily is going to be happening in the real estate market. You don't know necessarily if rates are going to go up, if the government's going to impose some new legislation that might cool or heat up the market. You don't know specifically. Just because the house across the street sold for a lot of money doesn't necessarily mean that yours is going to sell for the same amount of money. So they tried to make that argument, and the judge was having nothing to do with it. So Ontario Superior Court Justice Paul Sweeney came back with a judgment and basically said that this is a straightforward breach of contract case. There really is no extenuating circumstances. The buyers had a firm contract with the sellers, and they breached that contract. The judge further went on and actually wrote in his judgment that a drop in real estate values, even a dramatic drop, would not meet the test of frustration, impossibility, or be a force majeure. So he's come out now. We have written precedent now in case law that a fluctuation in the real estate market, even a dramatic one, would not qualify as unforeseeable circumstances or an act of God. So that defense basically is out the window at this point. So what the judge concluded was that it is a straightforward breach of contract case, and all that remains to be determined by a trial is the amount of damages that should be awarded. So that's what ended up happening in this case. So that's why we also recommend to all our clients, buyers or sellers, to keep track of everything that's happening, whether it's in a diary or on your phone or whatever it is, for expenses that you're incurring as you proceed through a real estate transaction. The sellers in this case had to relist their property, try to market it in the same way, and try in good faith to obtain the same price that they had originally received from the first buyers. They were unable to do so. They were able to document that they were unable to do so, and also document all their other expenses that went along with that procedure. Potentially they lost deposits on properties that they were trying to purchase, and again, like we mentioned, storage of furniture, moving costs, and then just general, you might be able to claim some stuff for general frustration, although that's a bit trickier thing to do when you're trying to account for damages. So basically, yeah, there's no way out of this. Once you have a firm deal, you have a firm deal. And unless there is a true act of God, which would be something like the buyer's dying. But even in that case, there is a term in the agreement of purchase and sale that indicates that the buyer's estate is obligated, and the seller's estate as well, obligated to proceed with the transaction. So the buyer's estate is obligated, if they can, to continue to purchase the property, and then they can dispose of the property however they want. So it's very difficult to get out of this. The damages go far beyond just the deposit that's been surrendered, and it works in both ways. Within my own brokerage, within the past 6 or 8 months, there was another case, not one of my clients, but where a seller breached contract. So buyers went ahead and purchased the property. When the closing date came, the seller decided not to complete the transaction, and that was not really sure what the reason was. Maybe the market had improved, was getting a bit better, so maybe the seller thought that they could get more money. They weren't happy with the original deal. Something may have happened in the seller's life that they decided not to move. Regardless, they did have a firm contract, and they were not allowed to break that contract, and as a result, the buyers had to go out and purchase another home. So they did purchase another home in the same neighborhood, but because the market had improved, were forced to pay $20,000 more. As a result, then the sellers had to pay damages to the buyers of $20,000 to account for that extra expense. So that's how it works. If you have any questions at all, I'm always happy to answer, of course, but I don't see any here, so we'll just leave it at that. I will presume that I did an amazing job of explaining it to y'all. I am Tony, the Geeky Agent. This has been Remax Geek TV, or at least my version of it. If you are looking for me online, I am, of course, here on YouTube, but I'm also on Facebook and Instagram. Facebook, YouTube, and Instagram is where the majority of my content resides, but you can also find me on Snapchat, Twitter, Tumblr, and Pinterest. Reach me by direct message anywhere there, or you can call me or text me at 289-237-9896. Drop me an email at tony@thegeekyagent.com. It gets filtered through my website, which is, of course, at thegeekyagent.com, or you can also look up hamiltonlifestylesearch.com, which will take you directly to the search portion of my website. So I really do appreciate you all tuning in. If you are watching me here on YouTube, which is always a good thing, have a look around. There's a subscribe button here somewhere. Hit the subscribe button, hit the little bell to get notifications so you can see future live broadcasts and videos. And as always, I love y'all. I hope you have a great rest of the day. It is amazingly nice outside today. Not too hot, not too cold. So I hope you have a lot of fun. I hope you have fun for the rest of the week. I am sure I'll be on here again. So until next time, as always, I'll talk to you soon. Bye for now.